Thank you, Senator Durbin. Senator Kennedy.
Thank you, Madam Chair, and congratulations, gentlemen. I thought I would just start down here and then move this way, if that's okay. Judge, what is the rational basis test?
Senator, I believe the rational basis test is going to be one of your least stringent tests, and whether a law has a rational basis for the outcome intended or the governmental interest that you're trying to obtain.
Okay. What if the legislature or the Congress, as the case may be, doesn't list a reason? What if they just pass the statute?
Senator, I would submit that probably happens many times, and I think it's the role of the court when determining such matters as a definition. I think it's the role of the court to determine whether the usage of that statute, using its wording in plain meaning, whether the usage of that statute is going to reach the governmental interest that you hope is obvious, but sometimes you have to determine.
So you just create the basis, the reason for the statute?
I don't think that you create it, Senator, but I don't think that most statutes, to be honest, I don't think that they tell you what they are trying to accomplish so much as they say, this is the law. For example, possession of a narcotic. It's going to say it's illegal to possess this. We determine if there's a rational basis that forwards the ends of the governmental interest.
Well, how do you determine if there's a rational basis? Do you look at the statute or do you look behind the statute?
Well, I think that you always look at the statute. Now, I think you also look at any other precedent or case law that has interpreted the statute. However, you look to the language of the statute to determine what it does and what effect that might have.
Okay. Counselor, let's suppose that a legislature passes a statute that says if you have a college degree or a more advanced degree, you don't have to take a driver's license test. And let's suppose that assume for a second that the federal court has jurisdiction over a challenge to the constitutionality of that test, of that statute, rather. What test are you going to apply, Counselor?
Senator, that would be a classification that doesn't turn on any sort of protected characteristic, and so it would be a rational basis test that would apply in that instance.
You don't see any suspect classification?
No, Senator.
You don't see any fundamental right?
No, Senator.
Okay, what if the legislature didn't provide, so you would use the rational basis test?
I would, Senator.
And you would uphold that statute?
I think there could be some rational basis that a court could conceive of to justify that statute, and rational basis is not.
So you would invent the rational basis, the reason for the statute?
That's generally how the test has been applied by the Supreme Court and by lower courts, and as a district court judge, I would be bound by that Supreme Court precedent.
Okay. Judge, tell me the difference, sir, between notice pleading and fact pleading.
Notice pleading, of course, goes to your due process issues under the 14th Amendment.
But what's the difference between notice pleading and fact pleading? We use two systems in America, as you know.
Yes, sir. Notice pleading is based on, of course, that goes into your jurisdiction, your personal jurisdiction.
In today's Senate Judiciary Committee hearing, Senator John Kennedy put forward sharp constitutional questions that dug deep into judicial philosophy. From the rational basis test to Brown v. Board of Education, Kennedy pressed nominees with direct and often challenging hypotheticals. This exchange revealed not just legal reasoning, but how future judges might interpret the Constitution itself. Senator Kennedy opened by asking the nominee to explain the rational basis test. The judge described it as the least stringent form of judicial review, where courts examine whether a law has a rational connection to a legitimate government interest. Kennedy then challenged the nominee with a crucial point. What happens when Congress passes a law without providing any stated reason? The nominee admitted that courts often look at the statute's plain meaning and precedent while inferring the possible government interest behind it. To test the boundaries of judicial reasoning, Kennedy introduced a striking hypothetical. What if a legislature passed a law exempting anyone with a college degree from taking a driver's test? The nominee responded that since the law didn't target a suspect class or implicate a fundamental right, it would fall under the rational basis test. Kennedy pushed further, asking if that meant judges would effectively invent a justification for the statute. The nominee confirmed that under current precedent, courts often do just that. Kennedy then shifted gears, pressing the nominee on the difference between notice pleading and fact pleading. While the nominee attempted to explain, confusion surfaced around which system federal courts actually use. Kennedy pointed out the critical importance of distinguishing between the two approaches in due process and jurisdictional matters. Perhaps the most intense exchange came when Kennedy revisited the question of how the Constitution should be interpreted. The nominee agreed that it should be understood according to its meaning at the time it was written. But Kennedy raised the landmark case of Brown v. Board of Education.
Your personal jurisdiction, and then the fact pleading, of course, goes into your subject matter jurisdiction.
What system does the federal judiciary use, notice or fact?
No, fact.
Okay. Judge, I'm about out of time. Can I have 30 more seconds, Madam Chair? You heard me talk to the nominee for the Third Circuit about how she would interpret the Constitution, and she said that the Constitution should be interpreted according to its meaning as understood by the people in America at the time the Constitution was passed. Do you agree with that?
I do, Senator.
Okay. Let me ask you what I asked her. How do you square that with Brown v. Board of Education?
I would adopt a lot of what she said, actually. I believe the 14th Amendment, as it came in, addressed.
14th Amendment was later.
It was later. It was a reconstruction.
Can you turn your microphone on, please?
Sorry
Thank
about
you.
that. I believe the Brown versus Board of Education is correctly decided.
I do too, but when my friends, and I'm a textualist as well, but when my friends say, well, we have to interpret the Constitution in accordance with the way the average American viewed the Constitution at the time. I say, okay, that seems fair to me. Do you think that the average American at that time?
The courts. Senator Kennedy's pointed questions exposed the complexities of judicial reasoning where hypotheticals, precedent, and philosophy collide. His interrogation left no doubt. The way judges answer these questions today will shape the law for generations to come. If you found this breakdown insightful, make sure to like this video, share it with others who care about constitutional law, and subscribe for more in-depth coverage of key Senate hearings and political debates.